Two, you may begin.
Thanks so much, Tony. Thanks everyone for joining. Good morning or afternoon, depending on your location. And I apologize for the delayed start. We just were working out some technical issues, but we're good to go now. This is the fifth installment of our Export Compliance webinar series. It's World Trade Month, and the U.S. Commercial Service takes this opportunity to host a number of programs to advise and educate U.S. companies about market opportunities and tradecraft skills. This session is a part of a 10-part series focused on export compliance, and it will cover deemed exports. My name is Jacqueline Roeder, and I'm an international trade specialist based out of San Diego with the U.S. Commercial Service. I'll be moderating today. Thanks so much for joining us. We have an amazing program lined up for you. Before we begin, I just wanted to quickly outline the full export compliance webinar series. Many of you are familiar with the program and are registered for the entire series already. Last week, we kicked off the program covering some export basics with EAR, ITAR, and OFAC. Earlier this week, those who registered heard a presentation on license exceptions. And today, as I mentioned, our presenter will focus on deemed exports. The rest of the sessions are listed here, and registration is still open. If you're interested in one or more of the following sessions, please feel free to inquire about the link. Our presenter today is Robert Bowen. He is an international trade attorney holding both a JD and an LLM with a focus on export control laws, economic and trade sanctions laws, and customs laws of the US, along with several other countries. He has extensive experience leading global trade compliance teams at publicly traded technology and aerospace companies. Right now, he serves as the Export and Trade Compliance Counsel for ServiceNow, a software company that develops a cloud computing platform to help companies manage digital workflows for enterprise operations. And he's also incredibly active on the deck here in San Diego and Imperial County. That being said, Bob is leading this discussion in his personal capacity and not on behalf of any entity or organization, including ServiceNow, and thus there should be no attribution of his remarks to any other entity or organization. And last thing before we begin, I just want to outline a few brief housekeeping items. You'll be muted throughout today's event in listen-only mode, but if you have any questions as we go along, please feel free to put them in the Q&A box in the bottom right-hand corner of your screen, and be sure to direct your question to all panelists so we can all see them. We will wrap up this webinar with a Q&A, and we will do a Q&A portion midway through if questions pop up. So we'll do our best to get through to as many of your questions as possible. Finally, this event is being recorded, so if you have any issues with participating in a recorded webinar, please drop off now. It is now my pleasure to hand it over to our speaker today, Bob Bowen. Thanks, Bob.
All right. JQ, thank you very much. I really do appreciate the opportunity and really give a tip of the hat to this series of webinars. I think there's some great content that's going to be made available through them. And I am very happy and delighted to spend some time on a tricky question that is part and parcel of complying with U.S. export control laws. Hi, my name, as JQ indicated, is Bob Bowen. Good morning. I think there's some good afternoons and maybe even a good evening there along the way. I have prepared some slides on this PowerPoint deck. We will go through them just as discussion leads, if you will, but I absolutely do encourage any and all comments or questions through the means that JQ has identified. We will have sort of that stopway point halfway through to take any comments or questions. My hope and intent is to provide some substance that may be of immediate utility and value to you, but longer term to provide you some resources to which you might refer in the event that during the course of your day-to-day work, some of these questions come up. Thanks, and next slide, please. Okay, big picture, right? We could call this an executive summary, but let's just stick to the big picture. Be that as it may, there are four key bullet points here. I probably won't go through every single line word by word, verse for verse, if you will, but just to sort of hit on a couple of the big topics here. Some of you probably are aware that there are two sets of export control laws in the United States that individually control the hardware, software, and intangible technology that is exported out of the United States for most immediate purposes for our time together here today. Sometimes the controls can be quite tight and quite onerous. In other cases, far less so, because there's just nothing regarded under the laws as being sensitive about either the technology or the recipient or the location. I think the key punchline here is actually that fourth bullet point, and that is, and this is really sort of a segue to the rest of our time together here, and that is that the release of intangible technology to someone who is not a US person inside the United States is regarded as being a release of that intangible technology to that person's country of citizenship. That is the concept of deemed export. It is deemed to be an export of that intangible technology to his or her country of citizenship, notwithstanding the fact that the transaction, if you will, took place in the United States. And that last concept and that last dynamic is going to be the subject of our time together here today. So next slide, please. Okay, this slide, and again, apologies, there's a lot of ink and a lot going on here on this slide. Again, this is a good example of where this may be sort of future reference point, but I thought that it would make sense to dig in a little bit into this idea that in the United States, we have two rather different sets of export control regulations. And here I'm attempting to segregate and divide them in a way that is consistent with the subject of our time together here today, namely deemed exports. At the risk of stating what some of you may already be aware of, let's spend a minute or two on the EAR, the Export Administration Regulations. The EAR have been around for decades. They are enforced by the U.S. Department of Commerce, and in particular, the Bureau of Industry and Security within the Department of Commerce. Their tagline, if you will, is that the EAR governs the export, re-export, and in-country transfer of dual-use items. Now, that term dual-use items itself probably requires a little bit of discussion, because I think the term dual use can be easily misunderstood and misconstrued. The term dual use really means nothing more than an item that was designed for a commercial or civilian application, but that can also be used, at least in concept, for a military application. And there's all sorts of examples, either around your home or around your office, including the very laptop that you may be using, or your cell phone that you may be using during this webinar today. I'm holding in my hand a ballpoint pen. That ballpoint pen is regarded as a dual use item, because even though it was intended for purely civilian purposes, if you will, to write notes, or to write a happy Mother's Day card to your mother coming up, that ballpoint pen in concept could also be used to design a thermonuclear weapon. And in that regard, it's regarded as being a dual use item. The EAR has its own definition that will be really relevant to our discussion today of what is technology. And I get into that later on in the slide. But before we get into the two different definitions of the items at stake here, let's talk about the other set of export controls in the United States, and that's the ITAR. the International Traffic in Arms Regulations. The ITAR are enforced by the U.S. Department of State, and in particular, the Directorate for Defense Trade Controls, DDTC, within the State Department. And the ITAR are quite different, to put it mildly, from the EAR in the sense that the ITAR explicitly apply to articles and their related services and technologies that were specially designed for a military purpose or for a military application. So, for example, a intercontinental ballistic missile certainly is not a dual use item because it was not designed for a civilian application. It is overwhelmingly and exclusively for a military purpose. That in turn means that jurisdictionally, an intercontinental ballistic missile is subject to the ITAR, but not to the EAR. And I think a key point that is crucial to understand, not just for purposes of deemed exports, but indeed for all of export controls, is that with some incredibly narrow exceptions, there is not much overlap between the EAR and the ITAR. And indeed, it is the case that a given piece of hardware or software or item of intangible technology is subject to one or the other, but not simultaneously both. And so one sort of bigger picture shout out that I think needs to be made right at the outset is within your organizations, I would strongly suggest that you first arrive at solid documented determinations as to whether or not a given product family or indeed maybe your entire business is subject to either the EAR or the ITAR, because as I said, I would submit that you are not developing and designing products that would be simultaneously subject to both. Okay, with that sort of why in the road, so to speak, that disjunction, if you will, at a high level between the EAR and the ITAR, I'm afraid we've got to sort of dual track the next couple of minutes of this discussion because, unfortunately, the EAR and the ITAR have different definitions of, on the one hand, what the EAR calls technology, but on the other hand, what the ITAR refers to as technical data. This is, however, though, a more of a superficial distinction and difference than a substantive difference for the most part, but there are some exceptions to that, as there are in a lot of other areas. I'm going to, however, though, assume, just for the sake of the next minute or two, assume that I think most of you are likely to be working in EAR environments as opposed to ITAR. I might be wrong in that assumption, but please bear with me. But for those of you who are subject in any way to the ITAR, I've attempted to provide the EAR definition of technology. And it's a little wordy, it's a little clunky. Apologies for that. It's literally just coming from the EAR. But I think there's some critical aspects of that EAR technology definition. We don't have time to burrow into each and every one of those, but you'll see that it's a very mechanical definition, if you will. By the way, many of those terms within that EAR definition of technology themselves are defined in the EAR. But one of the first places that I would direct you to examine afterwards is, in fact, how that definition of technology squares with the information that your organizations consume, generate, and, if you will, distribute to any of your customers, because that, for purposes of assessing your deemed export risks within an EAR environment, if you will, that's really where the action is. With respect to the ITAR, again, we the government doesn't do us many favors by like literally having different terms, but again, small problem in the scheme of things. Again, I have tried to provide what I believe is simply the straight ITAR definition of technical data. You will see that there are some parallels to the EAR definition of technology, but yet again, some differences. And one of the more notable differences is for those of you who are operating perhaps with classified information relating to defense articles and defense services. Absolutely, you are caught up in this definition. The final point on this slide, again, just sort of, just again, sort of reiterating this. The arrival at EAR technology and ITAR technical data is done in most instances with reference to hardware or software. And there are some exceptions to that. Those of you, for example, might be in software companies, know what this will be all about. Hardware, absolutely, but it's the case that, and if you look at and really think about those EAR and ITAR definitions above, they define technology or technical data with reference to something else. And that with reference to something else is with reference to, in most cases, hardware or software. Let me go back to the example of the ballpoint pen sitting in my office right now. Let's assume that that ballpoint pen is that piece of hardware. Well, the engineering designs and the specs and the blueprints and the 3D drawings that went into designing or manufacturing that ballpoint pen would be captured by that EAR definition of technology, because the ballpoint pen, that's the hardware, is subject to the EAR, and therefore technical information, if you will, related to that ballpoint pen is a good candidate for your review as to whether or not it's captured by that EAR definition of technology. Okay, let's pause here at this point because we're a couple of slides into our presentation, and we could stop again at another couple of slides, but let me pause now, JQ, just to see if there are any comments or questions that may have been received.
We do have a couple questions. I'm not sure, you might be touching on them at the next slide. So I'll ask you first. Someone asked, is there assistance provided for companies that are trying to figure out if their technology would be controlled, if they're looking for help with that?
Sure. The answer is yes, absolutely. And there are multiple sources of that control. The government agencies themselves can help with that sort of initial classification determination. For example, if that's part of this question, there is a mechanism that's called a commodity jurisdiction process, whereby a U.S. company, for example, can submit an application to various agencies within the US government, essentially asking the US government to determine whether or not their products and related technologies are governed by the EAR or the ITAR. In terms of compliance assistance on a day-to-day basis, the BIS has a very robust Office of Exporter Assistance. I think at the end of this presentation on the back slide, I think I set out some resources. I'll draw attention to at least one of those resources right now, and that is that the BIS within the Department of Commerce, I think, has an outstanding menu of resources available through their Office of Exporter Assistance. Yes.
Perfect. Thank you, Bob. And yes, that is on the end of this presentation, so we'll be sure to bring everyone's attention to that as well. And then the next two questions, I'm not sure if you'll be covering, but I'll let you know what they are, and then you can mention if you're going to be covering it. How are individuals handled who are permanent residents or citizens of countries other than those of their nationality?
Yeah, give me one or two slides and we're going to get there.
Okay, and then I am assuming you'll cover this too. What kind of documentation or information is required in support of a license application for a
Sure.
deemed export?
Sure, absolutely. We will get there. So let's say next slide for now then.
Okay, perfect. We'll move on then.
Okay. Again, perhaps a bit of an apologies in order. This is sort of a messy, busy slide, but again, we'll make some sense of this. I thought it would be helpful just to point out, just sort of demystify things a bit, and that is the form of EAR technology and ITAR technical data. No pun intended, but it really is usually not rocket science. It is simply the blueprints, the drawings, the photographs, the documents, the oral communications, and the visual observations. Maybe those last two are a bit surprising, but the way to think about how your organization is generating and handling technical information in a way that is relevant to the deemed export analysis is just to ask, how is it that otherwise in your ordinary course of business is your organization transacting and sharing technical information, whether it's EAR or the ITAR? So there's nothing really unique about this. I will say though, let me circle back to the oral communications and the visual observations. As I said, this actually might be a little bit of a hook, because I think people sometimes don't always appreciate that through those oral communications and through those visual observations, there could in fact be the release of EAR technology and ITAR technical data. And again, don't take my word for it. The government agencies believe that there are just those kinds of releases. Now, this is important when you think about an engineering team in the United States, or a manufacturing team in the United States, or even an administrative support team in the United States. There are oral communications and visual observations going on all the time. I think the one thing that needs to be really understood here is that those can be enough to release potentially export controlled information to a recipient who is not a US person. With that, let's go to the next point. Let's talk about, and this actually I think will pull in one of those questions. And this is, I think, a really critical point here of the entire presentation. Um, we need to understand what these regulations mean when they use the term US person. And I provide there in the note there the sort of operating understanding of what a US person is. A US person is anyone who falls into one of those five baskets. So if you will, there are five baskets that sort of collectively are referred to as a US person. So US citizen, US lawful permanent resident, a US asylee, a US refugee, and an individual who has been granted a form of temporary protected status, if you will. Together, those individuals are what the law refers to as US persons. The way to think of this, I believe, is that for your employees in the United States, once you determine that your employees in the United States are US persons, you might breathe a little bit more easily about any potential deemed export risks. And the reason for that is because both under the EAR and the ITAR, US persons are, as a practical matter, exempt from these export controls. So, with respect to EAR controls and ITAR controls, US citizens working in the United States for a US company are, as a practical matter, exempt. So there would need not be a deemed export analysis and review to ensure that there's no deemed export risks with respect to your US citizen employees. And it's the same answer for all of those other baskets within the US person categorization. So I think the way to think about this in a little bit more of a detailed way is that one needs to be aware of whether or not persons working in your offices do or do not qualify as US persons. And it tracks and it follows that, and I'll sort of use this to sort of illustrate the point. Suppose that after you're talking to your human resources department, you are comfortable in concluding that, and I'll just sort of pick a number, 90% of your US based workforce are US persons, but 10% are not. I would then think that that data focuses your deemed export attention towards the 10% who are not US persons, right? I'm not saying that you should, forget about the 90 who are US persons. And indeed, there are some good reasons why you shouldn't. But if you are confident in the reliability of your data that indicate that indeed 90%, in my example, of your US based employees are US persons, I would then suggest that you dedicate your resources to the other 10%. In the rest of this page, I try to illustrate a couple of real life practical examples as to really, no fooling in the real world. How does this work? What does this look like? And again, I'm not going to read those examples line by line here, but the basic idea here is you have a US based engineer who works with a colleague in her company's subsidiary in Germany, right? So Mary and Adrian are colleagues, they work for the same company. Mary in the US, Adrian in the US company's German subsidiary. Adrian is not a US person. When Adrian visits, and suppose that he comes here to visit, for a 2-week stay, if you will, to collaborate with his US based colleagues, whatever information is released to Adrian, because in my example, he is not a US person, that information is subject to US export control laws, because the idea is that because Adrian is not a US person in my example, whatever information Adrian receives and absorbs during his time in the United States goes back to Germany with him. That's the idea. That's how and why it is, even though in my example, Adrian is sitting right next to Mary in a conference room, the law deems whatever information Mary provides to Adrian during his temporary stay in the United States as being exported to Germany. It's a deceptively straightforward proposition. The idea is that when Adrian goes home, he will take with him everything that he heard and learned and absorbed during his time in the United States. Therefore, That means that when Mary and her colleague, because presumably she may not be alone, are having these engagements with Adrian in the United States, those engagements would be subject to the deemed export controls of the United States. By the way, let me also throw one thing here, which I think may not be necessarily clear. Even if Adrian were still back home in Germany, right? So you've got, in my example, Mary in the United States, based in the US, let's say, Adrian based in Germany. Even if Adrian is not in the United States physically, and Mary and Adrian are just collaborating on an engineering project in the normal course of their business, be it via email or Zoom session or SharePoint sites, telephone calls, believe it or not, those are all exports as well, subject to export control laws, because the idea would be that it would be information going from the United States to Adrian in Germany. It's just that in a deemed export context, if you will, when Adrian comes to the United States for his temporary visit, he brings Germany with him. But I just wanted to sort of flesh out this idea that even if Adrian is back home in Germany, Mary's company still has to be mindful of export control laws in their day-to-day interaction with Adrian. Okay, let's go down to the sort of the second tier example here. Same basic set of facts, except crucial difference here. Adrian first comes to the United States on a temporary work visa, be it an H visa or an L visa, something that does not confer on him any status that is within the US person category. While Adrian is here, let's say on his H visa or his L visa, he remains a non-US person. Therefore, deemed export control laws apply to him even though he has an L or an H visa to work here in the United States. That L or H visa grants him the employment eligibility to work in the United States. However, it does not cure any export control issues. That's an immigration law construct, not an export control law construct. So we still have to be mindful of export control laws during Adrian's time here on his L or his H visa. However, to like complicate things slightly, suppose after some years here on his L or his H visa, suppose Adrian is granted lawful permanent residency status in the United States, otherwise known as green card status. Once Adrian acquires lawful permanent residency status, as demonstrated by his green card, the game changes. He is now considered a US person, therefore is no longer subject to export control laws, or to be more precise, his company would no longer have export control obligations in what they release to him while he's in the United States, because he is now regarded as a US person. But that relaxation of these laws only comes about once he becomes a US person. Before then, these laws apply, but not after that, as a practical matter. Okay, next slide, please. Okay, this is a little bit of a roadmap on how you might want to think about taking some next steps. Some of this we've already sort of nudged up against. Some of this we've either explicitly said, or at least sort of implied and inferred. But I certainly think that it's reasonable to, as you're sort of thinking about step 1, 2, and 3, I definitely think that it makes a lot of sense to come to an understanding of the folks that you have in your US based workforce. I will say this is a webinar on deemed export laws, not employment law or employment discrimination law. I will say though that that review has to be done carefully and thoughtfully so that there are no suggestions that it is done in a way that is discriminatory, if you will, on a nationality basis, if you will. There are ways that this can be done in a way that is appropriate and entirely lawful. Certainly, the HR departments need to be really, really involved here, because I think that there needs to be a review of data to understand. Again, my example a couple minutes ago, is it 90-10? Is it 100% zero? Is it 60-40? I think that there needs to be a person by person assessment and understanding about the presence of either U.S. persons on the one hand or non-U.S. persons on the other hand in your organizations. I think another reasonable step is to really sit down and thoroughly assess the jurisdictional nature of your organization. Truly, are you an EAR organization? Are you an ITAR organization? Or are you both? And there are companies who are both. There are companies who have EAR businesses and products, and there are companies who have ITAR businesses and products. They're under the same roof. It gets complicated, but different products, one subject to one versus the other, are absolutely a common factor in many companies. And so I would be very, very careful in identifying and delineating your jurisdictional scope, if you will, and then in turn, really, really looking at the types of EAR technology, and or ITAR technical data your organization generates on a day-to-day basis, and then understanding whether or not there are non-US persons who may actually have any access to that EAR technology and or the ITAR technical data. Okay. Now, just to sort of put a little bit of a pin in that, let's then just work on the assumption that there are non-US persons present, and there really is EAR technology to be released to those individuals, and or ITAR technical data to be released to those individuals. Now what? And this sort of gets to that question about what goes into a license application if you find yourself really needing one. Well, we could spend a lot of time on this, but be that as it may, again, sort of sticking to our parallel pathways, there is a different next set of steps in the EAR as there are in the ITAR. So let's first of all unpack a little bit about what this looks like if and to the extent that you are regulated by the EAR. I think the critical question here is to determine whether or not at the end of the day, your organization needs further export authorization from the Department of Commerce. And I'm choosing my words a little bit carefully here, because just because there is EAR technology being released to a non-US person does not mean you need an export license from the Department of Commerce. Let me repeat that. Just because you have EAR technology to be released to a non-US person does not mean automatically you need an export license from the Department of Commerce. There is a significant analysis that still needs to be done to determine whether or not this technology going to this individual requires Department of Commerce export authorization. For example, it is the case that in many, many areas of, industrial sector activities, if you have individuals, from countries allied to the United States, for example, there's actually a very, very good chance that your proposed release of EAR technology to your non-US persons in the United States will not need further authorization from the Department of Commerce, either because the technology is not controlled to nationals of that country. That's probably the most common reason. So a blueprint that is proposed to be released, for example, to an Irish national working in your facilities in the United States may or may not need further export licensing from Commerce in order to release that blueprint to that Irish national, say, working, in your facilities in Washington State. Change the facts a little bit though, and you could have a very, very different answer. So the other way that you could possibly get comfortable not needing export authorization from the Department of Commerce is if you determine that even though a license might initially be required by the EAR, you have available an exception to that license requirement. It's a little clunky the way this works, but you first need to conclude that you need a license. You then determine whether or not there is already an available exception to that license requirement. And I tried to shy away from providing legal citations, but I gave one here on this slide. I'm talking about, some of you are probably quite familiar with this, the various EAR license exceptions that are found in section 740 of the EAR. Again, that's an entire webinar in and of itself. Some of you may be already familiar with this. Be that as it may, the availability of a license exception could be another way where you get comfortable that you actually don't need further licensing from the Commerce Department to release, in my example, that blueprint to that Irish person in your office. If nothing else, and you really do find yourself, needing to apply for an export license from the Department of Commerce, again, those forms are available on the Commerce Department's website. And so they're actually quite good. There are some good instructions in those forms. I will say, though, that just at a very high level, you are absolutely going to need things like the individual's resume, the position description, a broader description of who your company is, and a very detailed assessment of the information that you wish to release to that individual, right? So you have to talk about the recipient, you have to talk about the job, you have to talk about your company, and you have to talk about the kinds of EAR technology that you propose to release to that person. All right, let's shift gears here quickly and jump over to the ITAR. It's actually a somewhat similar analysis. In some ways, it's a little bit more abbreviated, just for two reasons. Number one, the ITAR is much more restrictive by and large than the EAR is. So whereas in the EAR, there's actually a fair chance that you might be able to release this technical information to your non-US person and colleague. That possibility is greatly reduced with respect to the ITAR. And indeed, the paradigm is almost stood up on its head. I think that there should be an assumption, a working assumption, that in nearly all cases, ITAR technical data does require some authorization, some affirmative authorization from the Department of State to be released to a non-US person. So it's almost standing the EAR sort of analytical model up on its head. Not literally, but I think just that's the change of framework from one to the other. There are some very limited ITAR license exemptions. They're kind of the parallels to the EAR license exceptions. Of course, there's got to be a different name. EAR calls them exceptions, ITAR calls them exemptions. There are some very, very limited ITAR license exemptions available. I will tell you, I wouldn't get my hopes up that you would be able to actually use any of those ITAR license exceptions. Therefore, if you are certain that you are subject to the ITAR and you believe that you have a legitimate need to have a non-US person in your organization in the United States, I would be very much of the mindset that that road is going to lead towards you needing to file a license application with DDTC in the State Department. Okay, we have spent a fair amount of time on this slide. I think it's warranted. I think it's justified. I think this is really, really crucial from a sort of an operational sense. I think that this is sort of where, if you will, the sausage is being made sort of within the organization. Some of it is going to get messy. Some of it is not going to be elegant and whatnot. But this is real. These are the hard yards, if you will, of where the real nuts and bolts work is done. Maybe what I should do is just touch base and see if there are any comments or questions at this point as well. If not, maybe we should go to the next slide because I think we're not far from the end anyway.
Sorry, Bob. I was having issues with my headphones, but yes, we do have a lot of questions that have come in. Someone requested clarification on the example of Adrian and Mary. I believe you answered this, but if Adrian is a US citizen but physically in Germany, it's not considered a deemed export, correct?
That's actually a very good question.
Okay.
That's actually a very good question. And it gets complicated in the sense that there would have to be an analysis of who owns his employing legal entity. So I would say I understand the question, and I feel much better about Adrian being a U.S. person in Germany, but that's not always the end of the story. So
Okay.
I would say I would feel good about that fact, but there would need to be a broader analysis done of what's the information, what encryption is being used to transact data to Adrian, notwithstanding the fact that he's in Germany, and again, the nature of his immediate employer in Germany. Yeah, good question. I think it's outside the scope of this webinar, though.
Thank you, Bob. And two people did inquire about people who have dual citizenship, one of them being a US citizenship. I don't know if you want to touch on that.
Yeah, so it's a very good question. By and large, and again, different general answer with respect to the EAR versus ITAR. In the EAR, the general rule is that the country of citizenship or lawful permanent residency that is last in time governs. So for example, suppose that you have an individual from, we can sort of pick the country, Malaysia, who then moves to Canada, okay, and becomes a Canadian citizen. For purposes of U.S. export control laws and any deemed export analysis that might need to be done, that individual would be regarded as a Canadian person because that Canadian citizenship was subsequent to the acquisition of Malaysian citizenship. Okay,
Thanks, Bob. And I know some of this it gets really specific, and we did get a lot of very specific questions. So I'm going to ask one more, and then maybe we'll go to your final slide, and
sure,
then we can, if we have time, touch on some of
sure.
the more detailed questions. But the last question I'll ask before moving on to that one is, um, if software is software and or technical data considered a deemed export if it's publicly available for download via a company website or GitHub?
Yeah, that's a very good question. The general answer is no. Um, with some incredibly small exceptions within the ITAR, fundamentally information that is publicly available with no barriers or obstacles to anyone obtaining it, by and large, is not subject to export control laws. There are some very narrow exceptions to that, which would be like serious corner cases, but fundamentally, the answer is no.
Perfect. Thanks, Bob. So we'll
Okay,
move on to your next slide and then resources, and then we'll hit some of the more specific questions.
sure, sure. Oops, next one. Yeah, there we go. Okay, so in the time that we have left here, again, the concepts that I'm trying to summarize on this slide are the desirability of technology control plan. And as I said here, and this sort of slightly gets back to that question or asked earlier, about I guess it was in my example. Once we conclude, I think my example was we've got 90% US persons, 10% non-US persons. Is that the end of the story? I would suggest to you that that should not be the end of the story. And indeed, I think it makes a lot of sense to memorialize, if you will, at least for that 10%, if not for your entire US based employees, some semblance of a technology control plan so that you have memorialized the nature of the EAR technology or the ITAR technical data, that at least what your non-US persons have access to during the day-to-day work for which you are employing them. I think it makes a lot of sense to have these TCPs, if you will, in place, because I think it's both cause and effect. I think it's a good practice to do this because it forces the analysis, it forces the memorialization of the analysis and your conclusions, and at the end of the day, if there is ever an inquiry from a regulatory agency, I think you would want to be able to demonstrate that you took the time to do this analysis and you demonstrated an awareness that there was even an analysis to be done in the first place. These are multi-functions, legal needs to be involved, human resources need to be involved, and the function that is actually employing the individuals in question also need to be involved. This can be complicated. Your IT team needs to be involved. Remember, information that is transacted in emails, that can be a release of EAR or ITAR technology or technical data, as the case would be. So emails matter. And I know that that's something that is odd in some ways when you think about it, because just how ubiquitous emails are. Trust me, the technical content of emails matters for purposes of export control laws. But a TCP is a way to demonstrate that those questions have been asked and answered. Technology roadmaps, likewise. Technology roadmaps are crucial. That way you know where the export restrictions might bite, if you will, because remember, in some cases, these restrictions can be significant and meaningful. In other cases, not so much. I think that a company does itself favors by laying out its technology roadmap so that in turn it understands the individuals that it may or may not be able to hire for crucial roles within that technology roadmap. I think it avoids a lot of consternation among your hiring managers, especially in technical functions such as engineering. Okay, next slide. Okay, yes, here are some links that I think are quite helpful. I do definitely recommend that if these subjects and topics are meaningful to you and to your companies, that you spend a lot of time on them. And as you'll see, I mean, I'm essentially suggesting resources available on two government websites, the BIS and the DDTC. I will tell you, in my experience, there is, at the end of the day, probably more information on the BIS website than there is on the DDTC website. I think DDTC is putting more and more guidance and information on their website. I think it's a helpful website. I think the BIS website, though, is very robust. I think that there is a lot there, and I think that BIS should be thanked, because I think that they have really worked hard to be transparent with guidance documents. And as I said, they've got an entire team of people there whose sole mission is to provide guidance and assistance to U.S. exporters.
Thank you so much, Bob, for that presentation on such a complex and very multifaceted topic. A lot of the questions that came in are very